Hi class! Now let's have a review on the remedies of the parties in a contract of sale. One of the remedies of the seller in case of movables is that when the contract of sale is still executory in stage, meaning there is yet no delivery of the subject to the buyer, the seller has the right to resell the subject matter of sale to another when the buyer fails to pay the purchase price. How about sales of movables on installments under RECTO law? When we say sale on installments, there are at least two stipulated payments in the future, whether or not there is a down payment. RECTO law prevents a seller, mortgagee, from seizing mortgage property, buying it at foreclosure sale for a low price, and then bringing the suit against the mortgager for a deficiency judgment. The result would be that the mortgager found himself minus the property and still owing practically the full amount of his original indebtedness. So the unpaid seller's remedies are not cumulative but alternative and exclusive, and they are as follows. 1. Exact fulfillment of the obligation. 2. Rescind the sale. Or 3. Foreclose the chattel mortgage on the thing sold. If the seller should foreclose on the mortgage constituted on the thing sold, he shall have no further action to recover any unpaid balance of the price. Let's go to immovables, particularly sales of subdivision lots and condominium under PD 957. PD 957 directs every developer of real property to provide the necessary facilities, improvements, infrastructure, and other forms of development in the subdivision or condominium. In case the developer fails in its obligation, the buyer has the option to demand reimbursement of the total amount paid or to wait for further development of the subdivision and suspend payment of the installments until such time that the developer has fulfilled its obligations. In PD 957, the buyers would be justified in suspending payments when the developer fails to give a copy of the contract to sell, despite repeated demands. The buyers also have the right to have the contract to sell registered with the Register of Deeds to bind third parties. PD 957 also imposes on the subdivision developer the obligation to cost the transfer of the corresponding certificate of title to the buyer upon full payment. Developers' lack of certificate of registration or license to sell merely subjects it to administrative sanctions, but do not render the sales entered into on the project null and void. Now let's proceed with MACEDA law, which covers sales of residential realty on installments under RA 6552. MACEDA law seeks to protect buyers of real estate on installments against onerous and oppressive conditions. It recognizes the seller's right to cancel the conditional contract of sale upon non-payment of an installment by the buyer, which is simply an event that prevents the obligation of the vendor to convey title to the buyer. The cancellation can be effected as follows. First, the seller should extend the buyer a grace period of at least 60 days from the due date of the installment. Second, at the end of the grace period, the seller shall furnish the buyer with a notarial notice of cancellation or demand for rescission, effective 30 days from receipt thereof. Third, for contracts covering more than 2 years of payments, there must be a return to the buyer of the cash surrender value. Until and unless the seller complies with these mandatory requirements, the contract to sell remains valid and subsisting. Take note that the decision rendered in an ejectment case operates as the required notice of cancellation under the MACEDA law. Note also that a formal letter of demand upon buyer to vacate the premises is not the same as the notice of cancellation or demand for rescission by a notarial act required by MACEDA law. And finally, note that the filing of an unlawful detainer case by the seller does not exempt him from complying with the said requirement. That's it for our review on the remedies of the parties. Thanks for listening.